Hi everybody, I'm Sapana Bania Rai here along with my group members Asma Paudel, Janisa Yanjan and Asia Karki. In these presentations, we are going to look after two different issues and will apply some rules and its applications on this issue. Firstly, we'll look after the contract law and its application in the part A, and will describe tort law and its application in the part B. Moving forward to the part A, the main issue of the part A is whether the Soberger restaurant is liable to reward the master model car to the Mickey and Braid. Moving forward, uh, moving forward to the contract law, a valid agreement is the foundations of the contract, but the agreement is initiated by an offerer, which refer the expressions made by the offerer, showing his expressions to bind himself in that contract. If has been approved. It can be the oral or the verbal, but the offer is different from an invitation to trade. According to the law, if the expression does not fulfill the elements of an offer, and then it refers to the invitations to the threat. Therefore, the acceptance of an offer leads to an agreement, and response made to the invitation to treat forms the offer. And generally, agreements is usually bilateral between two parties, and the other one is unilateral contract, where promises made by an offerer, where they have promises to give rewards or to pay someone if the events happens, and then they fulfill it properly. Offer can be revoked by the offerer if all the promises are not being fulfilled. To form the agreement, an offer has to be accepted. If the acceptance changes the terms of the offer, then the no acceptance occurs in the law. Usually, acceptance is said to be communicated when the offerer hears or comes to know about it. Now, I would like to call my colleagues Asma Podils to do the rest of my presentation. Thank you.
Thank you, Sapana. Now I'm here to continue a presentation. From the fact of the given case study, it has come to notice that a chain of restaurants named as SOO Burgers has started a competition to bootstrap its business. A token has been attached with the burger, and those who has collected 50 tokens is eligible to get a golden scratch ticket. Michael Mickey Marrow was highly interested to get the car. This is unilateral offer and not invitation to offer as here to offer mentioned. Due to some technical glitch, the restaurant has withdrawn the competition. The ticket he bought was locked for him. He scratched his ticket and and found he won the car. After getting released, he went to the office to get the car and to claim the prize, but since then the offer was validly revoked prior to its acceptance. No agreement is formed between Mickey and restaurants. Another customer played tricks to win the competition. He, instead of buying 50 burgers, collected 100 tokens he got, but later on he is not eligible to get the cars. This is because the acceptance has not been effected according to the terms of the offer. It is known that the result in a valid acceptance must be unqualified, unconditional, correspond to the offer. Thus, no agreement has resulted between Bread and Subburgers. So, among these two cases applications, the conclusion can be found out that the restaurant chain of SOO Burger is not liable to reward the Mazda model car to Mickey and Bread. Now I'd like to call Jonsai Yunjan for the further presentation. Thank you.
Thank you, Asma. I'm going to talk about rules and issues of Part B. Talking about issues, the issues that require analysis whether the bank is entitled to the remedy according to the case scenario. Um, Also analyzing upon the given set of the form, we would be briefly be considering the given relation of categorization applied to the given case, which would be help to relate and be able to examine how there can be important factor to the given current case scenario, and whether the bank is ideally entitled to the same remedy, whether the outcome will vary in the case. The loan was taken for renovating the clothes shop. The loan officer has knowledge of the bitter relation of Sarah with the board of the company. And talking about its rules, the issue of the present case study have to be discussed in the light of the doctrine of indoor management and the provision of Corporation Act 2001. The doctrine of indoor management has come into existence more than 150 years ago. It is also regarded as the Tarkod rules. This doctrine provides protection to the third parties who are dealing with the company. The doctrine of indoor management provides the possible safeguard in the case the doctrine of constructive notice is abused. And moreover, section 126 state that the authority of an agent to exercise the power of the company for making contract. Subsection 1 performing companies behalf can create a vary, discharge and even ratify the contract. At last, the agent can even exercise such power without using the seal. For further slide, I would like to call Asia for application and conclusion. Thank you.
Thank you, Jonisa. I'm here to explain about the application for this case. Here in this case, Sarah is appointed as a managing director of this company for 2 years, commencing from 8th August 2007. Her appointment was lodged by Australian Securities and Investment Commission and was subjected to the condition that she was not allowed to do any transaction or borrow money from the bank more than $20,000. On 20th December 2010, Sarah made a contract with the bank and lent her $30,000 for refurbishment. Although being against the constitution of the company, Sarah's act is still not considered invalid because the act of making transaction was against the constitution but was protected under section 125 of the act, which states that, quote, that any act done by the company which is against the prohibition or restriction laid in constitution is valid and the objects of the company can be set. Quote, no act of the company will be regarded as invalid just because it is found to be against or beyond the ambit of such constitution. Here, bank also had no knowledge of the content present in contract of Sarah and also about the return which was lodged by the company itself when she was appointed. Ignorance of the bank about this matter is protected by the doctrine of indoor management. When noticed by the board, it stopped paying all her loans as well as her interest. Then this act still cannot be justified because the board is still responsible for the act of Sarah, who is the authorized agent of the bank. So the bank, being a third party here, is not required to take consideration of the internal irregularities present in the company. Hence, in any situation, if any situation such irregularities is present, then the company will be responsible for it as the bank has acted in good faith and has no idea of the company's internal management. So, as a conclusion, Here, bank is entitled to the remedy according to the case scenario. Here, the bank is ideally entitled to the same remedy as well. And also, the outcome of this case will not vary. So, thank you.